זו הצורה שכולם מכירים את יהודה ושומרון. יהודה ושומרון, הקו הירוק נמצא כאן. לפני 15 שנה האמריקאים רתחו על שכונת E1. E1 זה שכונה שנמצאת ממערב למעלה דומים, שעדיין לא נבנתה, ונעשו בה עבודות עפר ועוד לא נבנתה השכונה הזאת. ולמה האמריקאים והערבים כמובן התנגדו מאוד מאוד לשכונה הזאת? כי השכונה הזאת מנתקת את יהודה ושומרון במותניים הצרות ביותר שלה, בין ירושלים לים המלח. זו הנקודה הכי צרה ביהודה ושומרון, וברגע שבנית את E1, השכונה הקטנה הזאת, ניתקת את שומרון מיהודה, הפכת את זה לשני אזורים מנותקים לחלוטין. הרצף ההתיישבותי הזה, הרצף האורבני הזה בין ירושלים לים המלח, מנתק את יהודה ושומרון. השיטה הזאת של ה-X עיגול הזה, המאבק הזה, בשיטה של X עיגול כבר קיים במדינת ישראל, ובעולם בכלל, אבל כאן אצלנו כבר 130 שנה. כששלחנו אצבע ארוכה לתל חי, זה היה הרעיון, לשים אצבע בתל חי. שהקמנו את רביבים ואת 13 הנקודות בנגב ב-43, זה היה השיטה. שב-36 הקימו בבקעת הירדן את טירת צבי, זה היה השיטה. איפה שיהיו היישובים, שם יקבעו הגבולות. והשיטה הזאת שלה, אנחנו שמים את ה-X והם את העיגול, ואנחנו יוצרים את הרצף, ויש כאן מלחמה על הקרקעות כבר 130 שנה, זה השיטה שעובדת. כאן אצלנו בגוש עציון, השיטה הזאת היא מאוד משמעותית. אני מראה כאן את כביש 60, מירושלים לחברון. הכביש הזה כאן נמצא צומת גוש עציון. זה הכביש לתקוע, והכביש לאלון שבות. היישובים הכחולים זה הקווים התיאורטיים של השטחי אדמות המדינה של היהודים. אפרת הגדולה של תמר ודגן נבנות רק עכשיו, ואיתם עדיין לא נבנית, אלעזר, נווה דניאל, ראש צורים, אלון שבות ומגדל עוז. זה מרכז גוש עציון. אנחנו כולנו יודעים שממערב לגוש עציון, בינינו ובין ביתר, נמצאים נחלים וחוסן, שתי עיירות מאוד גדולות, שכלואות בין הקו הירוק, צור הדסה, ובין גוש עציון. הן כלואות, והם מבינים את זה. הערבים מבינים מצוין שהנתק הזה בין נחלים וחוסן הוא בעייתי מאוד. כאן אנחנו מראים את הכתמים הכחולים של היהודים, וכאן נמצא נחלים וחוסן ובית לחם הגדולה. בית לחם הגדולה כאן. הרצף הזה שהם רצו ליצור כאן, הערבים רצו ליצור, זה הכתמים האדומים האלה. הערבים רצו ליצור איזשהו רצף התיישבותי באזורים האלה, ולכן קיבלו אישור. שר הביטחון אז, אפרים סנה, שלא היה סגן שר ביטחון, אבל בפועל לא היה שר ביטחון, כי ראש הממשלה היה שר ביטחון, קיבל את האישורים של המינהל האזרחי. המינהל האזרחי אישר להקים 11 חוות פלסטיניות, הכתמים האדומים האלה. 11 חוות פלסטיניות שקיבלו אישורים. עכשיו אנחנו יודעים שהערבים שיש להם קרקע, הם מאבדים אותה, הם לא מבקשים אישורים. מתי הם מבקשים אישורים לחוות פלסטיניות? כאשר הם רוצים לבנות באזורים שאינם שלהם, והם ביקשו רישיונות לבנייה. כאן זה ג'בל חבון, זה הג'בל שלנו. זה הבקשה שלהם. הבקשה שלהם כאן לבנות. והרצף הזה היה צריך ליצור רצף בין בית לחם והאזורים של ג'ורה תשמה וואדי ניס, אין נחלים, ליצור את הרצף ההתיישבותי הזה. והמטרה שלנו הייתה למנוע את זה. ובזה שהקמנו את נתיב האבות, פשוט ניתקנו את הרצף הזה. את הרצף שניסו הערבים ליצור לא רצף חקלאי, אלא רצף אורבני. כי רצף חקלאי קיים להם בלאו הכי. השכונה הדרומית שאנחנו רואים כאן, שכאן אנחנו רואים את כל נתיב האבות, השכונה הדרומית, גם היא נמצאת עכשיו מאוימת על ידי הממשלה בבג"ץ נוסף. כבר הוגש בג"ץ נוסף, אנחנו מדברים על הבג"ץ כאן, על הבתים שאנחנו נמצאים בהם עכשיו. נתיב האבות, אני מראה שעלינו ב-2001, זה הקווים שקיבלנו, הכתמים האלה, הכתמים הכחולים האלה, זה הכתמים שקיבלנו מהמועצה האזורית והמינהל האזרחי, ובנינו בתוך הכתמים הכחולים האלה. אלה היו הקווים שקיבלנו אותם. בנינו כאן, אנחנו מראים אותם. בשנת 2014, התחילו לעשות סקר סוף סוף. אחרי ש14 שנה היינו כאן, החליטו לעשות סקר ולבדוק את הקרקעות. ושמנו קו על קו, ורואים כאן שיש הבדלים. יש מקומות שההכרזה הייתה גדולה, יותר גדולה, ובסוף דייקו את הקווים. בדרך כלל שמדייקים את הקווים, זה בדרך כלל נגדנו. תמיד מהשטח הגדול נעשה שטח קטן. יש כאן מונח כאן שני שכבות. השכבה של הקו שיושב על הכתמים הצהובים, שיושבים כאן, ורואים כאן את הקו הכחול של ההכרזה. זאת ההכרזה שנעשתה. הבעיה שבכמה מקומות ההכרזה גרעה, אני מדבר עכשיו ב-2016 כבר, ההכרזה גרעה, כאן אתם רואים את הפסים האלה, אני אעשה זום אין לאזור הזה, אנחנו יושבים עכשיו בבית הזה כאן, רואים כאן רצועה דקה שעוברת כאן ועוד רצועה, נתקרב עוד קצת, אנחנו יושבים עכשיו בבית הזה. זאת ההכרזה של אדמות המדינה. שתי התולעים האלה כאן, נגרעו מתוך ההכרזה של המדינה. הבית הזה שחושבים בו נגרע מתוך ההכרזה כי הוא בתוך איזשהו מובלעת, שכאן מצאו קווי עיבוד. השופטת חיות אמרה בדיון, שאלה את העורך דין של שלום עכשיו, הרי הקרקע הזאת לא שייכת לאף אחד, אף ערבי לא הביא עליה בעלות. אין היום אף ערבי שיודעים להגיד שהוא הבעלים של הרצועה הזאת. הרבה ערבים טענו, אף אחד מהם דעתו לא התקבלה. ולכן השופטת חיות שאלה, מה תעשו עם זה? אז הוא אמר שהצדק צריך להיראות ולעשות, אבל כמובן שלא יעבדו כאן. אז את זה גרעו, ובגלל שגרעו את השטח הזה, יצא פסק דין חלוט שצריכים להרוס את כל הבתים שנוגעים, רק נוגעים. זאת אומרת, הבית הזה של משפחת שטרית, שרק נוגע פה בפינה הזאת, 2.5% מהבית, רק נוגע ברצועה, אותו צריך להרוס. אותו דבר עוד מגרעת של משפחת רגולץ וחי, האזור הזה, כאן, את זה צריך להרוס. המדהים היה שהיינו כבר צריכים להרוס, והרסו לנו כאן את הפרגולה של זכרו של עמנואל מורנה ועזרא אשר, שהייתה נמצאת כאן, כי פשוט אם היינו מזיזים אותה 12 מטר, אז זה היה מחוץ להכרזה, בתוך ההכרזה. זה גרעו את זה. עכשיו, אתם חושבים שזה היה מעובד? לא היה מעובד כאן כלום, כי זה היום הכרם של מני גרטלר. אז את זה גרעו, כי היה פה עיבוד פעם, מצאו כאן שרידי עיבוד. היום הכרם של מני גרטלר נמצא כאן, נגרע מתוך ההכרזה, והפרגולה הזאת כבר נהרסה. אנחנו בונים היום פרגולה אחרת בחוץ. עכשיו, זה נתיב האבות, שוב התמונות של הבתים, שאותם צריך להרוס. הבית הזה של משפחת שיץ, והבית של נוי, ושל יחזקאל ויחזקאלי, כאן כל הבתים האלה זה בתים שהולכים להרס כי הם פשוט נוגעים בתולעים. הבית של משפחת אהרונוביץ', חצי ממנו הקו, יש איזה מובלעת קטנה כאן בנגריה. הנגריה זה סיפור בפני עצמו, אני לא יודע אם צריך להעלות את כולם. זה הבתים. עכשיו עוד משפט אחד, שכונת הלולים, שבדרך שעליתם לאלעזר, יש שכונה שלמה שנבנתה לפני 5 שנים. השכונה הזאת נבנתה בזכות נתיב האבות, כי התב"ע כאן אושרה כי הייתה סמוכת דופן. הטענה בתב"ע, קשה מאוד לאשר היום טבעות ביהודה ושומרון ביישובים שהם בתפיסה צבאית. יש היום 70 יישובים ביהודה ושומרון שהם בתפיסה צבאית, ולכן לא מאשרים טבעות ביישובים כמו כפר עציון, שרוצים לעשות שכונת הרחבה. שנים מתעסקים שם עם הטבע, כי כפר עציון, שכבר הוקם ב-43, רוב השטח של הקיבוץ הוא תפיסה צבאית, ולכן לא נותנים לעשות שם טבע, תוכנית בינוי ערים לאשר. גם באלעזר, שזה תפיסה צבאית, לא נתנו לעשות טבע. למה אישרו לנו בסופו של דבר את הטבע? כי אמרנו שזה בין אלעזר לנתיב האבות, זה בתוך היישוב. רק בגלל זה שזה צמוד דופן, ובתוך היישוב עצמו אושרה טבע של נתיב האבות.
אושרה טבע של הלולים.
טבע של הלולים, סליחה, צודקת. אז זה מה שבאופן כללי. היום יש לנו כאן 17 מבנים שקיבלו צו הריסה, 2 מבנים כבר נהרסו. אחד, צבי אהרונוביץ' הרס את הנגריה שלו, חתך את הפינה שחרגה מאדמות המדינה, והפרגולה שנהרסה. כל שאר הבתים, 15 בתים, צריכים להרס עד מרץ 2018. אז עוד משפט אחד על זה. אנחנו עתרנו לבג"ץ, צבי אהרונוביץ' עתר לבג"ץ, כי הוא אומר, ביצעתי את הצו. חתכתי את הפינה שמחוץ להכרזה. עתר לבג"ץ, והדיון בנושא הזה צריך להיערך רק בדצמבר. הוא נקבע ל-25 בפברואר, כאשר ההריסה היא ב6 למרץ. שבועיים קודם ידונו בזה, הקדמנו את זה לדצמבר, ורק בדצמבר ידונו האם החיתוך של הבית שלו זה ביצוע של הצו או לא.
אבל זה רק נוגע לבית הזה?
לא, עכשיו אנחנו מצרפים לעתירה הזאת עוד 6 בתים. זה יקרה בשבוע שבועיים הקרובים.
שאלו הבתים היחידים שיש
מתוך 15 בתים יש 6 שאפשר להציל על ידי חיתוך קטן של הבית.
Hi, I'm Professor Eugene Kontorovich. I am the head of the International Law Department at Forum Kohelet. No, you can't hear? Louder? Louder, okay. I'm the head of the International Law Department at Forum Kohelet, a think tank in Jerusalem. I have been involved, along with other members of Forum Kohelet, in some of the efforts involving Hok Hasdara, unsuccessfully so far in this case, and work deeply with the international legal issues involving Yehuda v'Shomron and the Jewish presence here. With regards to places like Nativ Haavot and Amona, there are 2 sets of legal issues that were raised in the courts, that were raised surrounding the attempts to apply Hok Hasdara or some other legal solution to these places, and I'm going to focus. Those two issues are, one is a purely Israeli legal issue. So the issue of what happens if some property infringes on private land, what has to happen, that's an issue purely, it's not an international legal issue. International law doesn't talk about property issues, local property issues. And the idea that the solution for the kind of problems that were just described is to require the government to destroy the houses involved, that's a local Israeli domestic thing. That's not an international law thing, and it is also very weird by general Western standards. For example, in the United States, the courts cannot require the government to evict people, to destroy properties, and certainly if people live in a certain place for a certain period, there is a doctrine, a rule of law throughout Anglo-American common law countries. The Ottomans also had it, the British also had it, that if you're in a certain place and nobody complains, it's yours. But even if people do complain, in situations like this, what would be the solution? For example, under American law, certainly the solution would be, there's a legal name for it, a prescriptive easement, would be to pay whoever is claiming it, whatever it's worth, and not to require destruction, because obviously destruction costs far more than the alternative. And almost always in such cases, law does not require that a more expensive solution be taken over a cheaper solution. However, Bagatz is its own world and follows absolutely its own rules. But there is an international legal question. There's a general international legal question. For example, when Shalom Achshav makes these arguments about property, they don't really care about the property issue. That is to say, Shalom Achshav say, you have to knock down this place because a meter is built on Arab agricultural land. But what if it's not built on Arab agricultural land? They say you still have to knock it down because it's against international law. So the argument about property is not really the central argument. And when in the Knesset the arguments were made about Hak Hasdara, many of the people opposing it or opposing applying it to cases like this said it would violate international law. Now, there are many issues involved here, but first question is, what is the status of Judea and Samaria under international law? It's a big question. We're not going to get into it. I've written a lot about it, lectures on YouTube, but let's say the Yotzim Mishpatim are correct, and this is not Israeli territory. What's it mean? What's it mean? So
cannot decide what's going to be here.
That's a good point. Bagatz can decide anything, by the way. Bagatz can hear a petition from somebody not living in Israel, with no connection to Israel, about things going on in Israel. American Supreme Court cannot do that. So Bagatz can do, in its view, whatever it wants. Aaron Barak has said that Bagatz can declare an amendment to the Constitution unconstitutional. So if you can do that, you can do anything. The position of Bagatz is we only enforce the law and under the Constitution. But if the Constitution we don't like, we can say it's unconstitutional. So, but the Constitution that they've developed, the ideas of the Constitution. So the question of settlements, settlers in international law is only discussed by the United Nations in one context, Israel. And here's an interesting fact. When people talk about international law against settlements, they're referring to one sentence of the Fourth Geneva Convention. Now, the Geneva Convention is a convention about war, why it would apply to current circumstances where obviously there is no war, most peaceful corner of the Nativ Haavot, most peaceful corner of the Middle East, no doubt. So That's a separate question. But that sentence does not use the word settlements, settlers, settling. That sentence says the occupying power shall not deport or transfer its population into the territory that it occupies. So why settlers? What settlers have to do with anything? Usually in law, when you're discussing a legal concept, from a treaty, from a statute, a mishpat, you use the words of the statute to define the concept. So, for example, in America now there's a big controversy about whether Donald Trump has taken impermissible benefits from foreign governments. How do we refer to that controversy? The foreign emoluments controversy. Why? Because the words in the Constitution says emoluments. So even though nobody even knows what that word means today, we use that word because it's the word in the legal provision. Where's the word settlements come from? It's just a translation of the Hebrew word yeshuv, which of course has yeshuv means settlement. If you translate yeshuv into settlement, is just what yeshuv means. So and of course, the yeshuv has absolutely no legal connotation. You can have a yeshuv here, you can have a yeshuv there, on this side of the green line, on that side of the green line. And the word yeshuv is accurate. These places are yeshuvim, small, new towns. But the fact that the international community uses a word, not from a treaty, not from a legal rule, but really taken from Hebrew, shows that we're not talking about something international, but something about Israel only. To give you an idea, the United Nations has referred to Israel as an occupying power 530 times more than it has referred to all other countries as occupying powers ever. It has reminded Israel of its obligations under the Geneva Convention an infinite number of times more than it has ever done so for all other contexts. Now the question is maybe there's nothing to talk about around the world. Maybe this is the only place to discuss these issues. So it turns out that many countries have occupied territory in wars. And many countries have occupied territory and held on to it for a long time. And what I have discovered in my research, and it's fairly astounding when you think about it, no country that has taken, no country, I mean in the post-World War II era, in the modern era, under the Geneva Conventions, no country that has occupied territory in a war has ever taken any steps to in any way restrict or prevent its citizens from moving into the territory. No country ever. But except with one exception. Israel, of course. Israel has done more to prevent what the international community calls settlement activity than any other country. No country has ever taken any such steps, and in no case has the international community ever criticized this. I'll give you some examples. Let's start with the beginning. Geneva Conventions are passed in 1949. America occupied West Berlin in 1945, at the end of World War II. When did the occupation of Berlin end? It's 1989, 1990. Because West Berlin was never part of the Federal Republic of Germany, it was separate. It was under occupation by America, Britain and France until the end of the Cold War. It was very long, and how long? The occupation could have gone on forever, by the way. If you ask someone in 1985, how long is America going to continue to occupy West Berlin? It's till the end of time, right? Till the Soviet Union collapses. Never did a single person, did a single lawyer suggest that America has to stop American citizens from moving to Berlin. Not even a law professor suggested it. And that's amazing. 45 years? Let me tell you a bit about the job of a law professor. We have to write all these articles. We have to make hidushim all the time. That's the job. All the good ideas have been written. So now the job of a law professor is to think up weird, crazy, marginal, arguable ideas. So if no law professor even suggested that there's an issue under the Geneva Convention if Americans moved to Berlin, which they did in non-trivial numbers for various reasons, that means like the idea would not even occur. It means it's not what you would ever think. Now, since then there have been significant occupations of territory that have seen massive movements of people into the occupied territory. Just to take some current examples that are still going on. Morocco occupied Western Sahara in 1975. Now the majority of the population of Western Sahara are Moroccan settlers. Majority. Which works out very well for Morocco, because what does the international community say should be done with Western Sahara? They should have a vote to decide their future. But guess who gets to vote? The Moroccans. Why? Because they live there. This was an issue that arose with Hok Hesderah. The opponents of the law said Israel cannot benefit its own citizens. Why not? They live there. They live there. They're part of the population. And when you look at how the international community treated similar cases, why did they let the Moroccan settlers vote on the future of Western Sahara? Because they live there. They've lived there for a few generations now. Turkey and Northern Cyprus. Turkey occupied Northern Cyprus in 1974. The majority of the population in Northern Cyprus are now people who've moved from Turkey. They're building houses for them every day. Russia occupied Crimea just in 2014. And the international community said it was bad and they condemned it. But what about the 100,000 Russian settlers who've moved just in the past 2 years to Crimea? No, the international community has not said a thing. Now, where do these people live? Obviously, they build houses. They build houses. They take houses that were existing. There are many such examples. Armenia and Nagorno-Karabakh. And many other examples. To take some of these situations have ended. Vietnam, when it occupied Cambodia in the 1970s, estimates say between 200,000 and 1 million Vietnamese settlers moved to Cambodia. By the way, also in the case of Northern Cyprus, in the case of Western Sahara, all the cases I've mentioned, estimates, guesses about how many settlers there are, vary by hundreds of thousands. So in Cyprus, people say, is it 100,000? Is it 300,000? In Morocco, is it 100,000? Is it 200,000? Why does nobody know? Because nobody's counting. And why is nobody counting? Because nobody thinks it matters. You count things that are important. When I write about these situations, I feel very uncomfortable as a scholar, waving my hand and saying 200,000 to 1 million Vietnamese settlers in Cambodia. What does that even mean? 200,000 to 1 million. It's a huge range. So I was like, where's Shalom Achshav when you need them? So obviously nobody's going around saying, look, Vietnamese house, Vietnamese house, Vietnamese house, Vietnamese house. In none of these cases has the international community said that this violates international law. Now, some people will say, well, just because everybody else is doing it doesn't mean it's okay for Israel. We should really follow the law, even if everybody's breaking it. But in law, that's not how it works. In normal law, just like in halacha, you go after the majority. If you have 9 cases going one way and 1 case going another, you don't say, the 1 case, that's the law. Everything else, that's just politics, that's getting it wrong. The 1 case is the law, the 9 cases are the exception. No, the 9 cases represent the accurate, how the international community actually sees the law. What's it mean? Why is it important? One of the things that is urged upon Israel is the following idea. If you want to be part of the international community, if you want to be treated like a normal country, you complain, we don't treat you well, we treat you like Jews, well, stop behaving like that and behave like a normal country, behave like a world citizen. Follow the rules that countries follow. Follow international law. That's the rule for countries to follow. Follow the rules, we'll treat you like normal people. Not follow the rules, we'll treat you like, not normal, like lawbreakers. And this goes on long before 1967. This has nothing, this is an old idea. An amazing thing. My former boss had this article framed above his desk. When the New York Times editorial, criticizing Israel very strongly, in 1961, after the capture of Adolf Eichmann. And what did they say in this article? It could have been written today. They say, of course Israel is treated harshly. Of course Israel is criticized. Of course there's a question mark about Israel. Because Israel doesn't want to behave like a good country. Israel is breaking international law. Should give Eichmann back. And then everything will be okay. So, when we see that the rules that Israel is told to follow do not seem to be the rules, they're not the rules. The question that has to be asked is, would following the rules that aren't really the rules lead to different treatment? As a lawyer, I would predict not. Because if the rules aren't the rules, following them isn't going to result in a different treatment. It's just going to result in a new set of made-up rules. And we've learned this so many times. We learned this after Gush Katif. The legal advisors to the foreign ministry were asked the following question. I heard this from some of them. The government said, we're going to leave Gush Katif, we're going to leave Gaza. We should at least get credit for it with the international community. What do we need to do to make sure that nobody can say that we're occupying Gaza anymore? And so the lawyers, who were not big fans of Gush Katif, they were happy to give very strong advice. They said, make sure you take out all the soldiers, but also take out all the civilians, and take out the bodies from the graves, take everything out, and then nobody will be, there is no basis, there is no way in international law you can be said to be an occupier. And if you had asked anyone in 2004, without mentioning the country involved, if a country has soldiers in an area, takes them out, occupation? They'd say, of course not. The International Committee for the Red Cross, they had a definition of occupation. What was that definition? So occupation lasts until the army of the occupying country leaves. That was their official definition. They actually had a meeting a few years ago to change the definition. So the occupation is when you have an army, and then it ends when the army leaves, except in a case where the occupation was very long, and then the country is still very powerful, and still has some influence, and there's still, in exactly that situation, then you'll still have an occupation. So I'm reminded, I don't know if you had this growing up in Israel, Charlie Brown, Peanuts. So Lucy has the football. And she always says to him, come on, let's play football. Let's play football. Kick the football. And Charlie Brown loves Lucy. And he wants her to love him so much. Every time she says, let's play football, he's ready to go. Maybe she's going to like him this time. And she pulls the football out. And he falls on his back. That's exactly what's going on. We want to kick the football. Get the rules right. Keep moving the ball. In relation to Hok HaSdara in particular, and applying it to situations like this, one very powerful thing that was invoked, that was raised to influence the government, was the International Criminal Court. The legal advisors said to Bibi, if you don't knock down these houses, they're going to prosecute you in the International Criminal Court. Nobody has ever been prosecuted for anything like this in the history of international law. Does that mean the International Criminal Court won't do it? No, doesn't mean that at all. But it does mean if they're going to do it, they're going to do it. They don't need Nativ Haavot to do it. They don't need a Mona to do it. You know, yesterday somebody probably closed off their merpesa in Gila. That's what they need. They have that already. If they're going to do it, they're going to do it. And however, I do think this is a very important factor with the government and with the Prime Minister in particular. Personal fear of legal proceedings. But there's nothing that can be done to prevent that. That is to say, to satisfy what the International Criminal Court's prosecutor might think international law requires. Everybody on the east of the Green Line would basically have to stop breathing and certainly stop having children. It would be impossible to satisfy. But it's still used, I think, to scare the Prime Minister. Very strangely, there's this idea that issues involving private property are somehow more serious, more fundamental than other kinds of issues. That's very strange. Because generally in law we think property is easy to deal with, because it's about money. Right? In the end, you have a situation like this. What do you do in a normal legal system? You pay the claim. That's it. As a matter of fact, the Turks in northern Cyprus set up such a system. Because the Turks, I told you the majority of the population, the settlers, the Turks do not need to build so many houses for the settlers in northern Cyprus, because they kicked out all the people who were there before. So it's a much more serious situation. There are really no Greeks left there. And so they live in their houses. And the Greeks started bringing legal cases in various European courts, and it was a problem for the Turks. So the Turks set up a system where if a Greek says that he has some property in northern Cyprus, where his family was from, he could submit a claim to a Turkish commission, and they would investigate and they would pay his claim if they felt like it. And they set up this system about 10 years ago, and some Greeks didn't like it, and they took a case to the European Court of Human Rights, saying you're not allowed to do this. You need to give us our houses. Kick out whoever's there, give us the house. We don't want the money. And the European Court of Human Rights said, of course it's okay to give money. Property, money, normal. And the European Court of Human Rights said the people there, now, the Turkish Cypriots, right, the Turkey invaded in 1974, said some of these people have been there for 20 years. You can't just kick them out. They have kids there. What did the kids ever do to anyone? That's what the European Court of Human Rights said. And of course, that is what Bibi is being told. If he accepts the view of the European Court of Human Rights, he'll be taken to the International Criminal Court. In the end, I think, if the government takes actions because of fear of the International Criminal Court, this would be the most likely thing to invite action by the International Criminal Court. Because the International Criminal Court has no power of its own. It doesn't have police to arrest people. It doesn't have marshals to serve warrants. So how does it proceed? It needs the cooperation of the country involved. So some countries tell them to get lost, like Kenya, and that's it, they can't have a case. So if the Prime Minister says, it's very horrible, I feel very bad about this, I have to destroy these houses though, because of the International Criminal Court. They read that, they're going to say, this is a country that's going to take us seriously. And in many ways, these international legal processes are like voodoo. Voodoo, yes, you know the word. It works if you believe in it. So, if the Prime Minister is saying, I believe in voodoo, the voodoo shaman is going to start sticking pins in him. Voodoo shaman, voodoo priests, don't stick pins in people who don't, in little dolls of people who have nothing to do with voodoo. And they know it's not going to help. So, unfortunately, the situation is quite bad. It's very important but the fundamental solution to this situation needs to address, I think, fundamental issues. And the fundamental issues here are, first of all, the government's refusing to adopt a clear policy about the legal status of Judea and Samaria. That's a problem. And the more general problem, the power of Bagatz. That's the real issue here. Government does not want to do this. The Knesset doesn't want to do this. Nobody really wants to do this.
I have a question in this.
But Bagatz can make anything happen. And they can set deadlines. In America, that would be unheard of. In America, if the court says somebody has a legal right to it, the government can say, okay, we will enforce that when we get around to it, when we feel like it. In Israel, the government can say that also. But then Bagatz can say, okay, time's up. Come on. That could never happen. And ironically, the Israeli Supreme Court says that it is using the American system of judicial review. Where did we get this idea of the court striking things down and telling from America? But nothing like this could happen in America. And the notion that having a Supreme Court that can do whatever it wants is essential to a democracy is not the idea of the role of the courts that was developed in Britain and America, from which these ideas were supposedly taken. Questions? Yes?
Yes. I want to be practical in this case.
Yeah.
You mentioned the Supreme Court and the government. Can you tell me very simple, what has the highest authority? Is that the High Court, or is it the government decision covered by a majority in the Knesset?
Outside of constitutional questions, government decisions have higher authority. However, the Supreme Court gets to decide what's a constitutional question. And they can say, as they sometimes do, government decisions that are designed. There's this idea in Israel, it's a very strange idea, I forget there's a word for it in Hebrew, when a law tries to change the result of a court decision. So that's considered a special kind of problem. Right, the court... Yes. In America, that's why Congress passes laws. It's considered very normal. The court decides the statute means one thing, or the statute requires something, or doesn't require something. Congress says, no, you got it wrong. And they'll pass a law saying from now on, even if you thought so previously, new rule. Never has it ever, no, it has never happened because I believe it has never happened because everyone is afraid that then the Supreme Court will actually finally say what it may be thinking, that you can't do it. In America, it's not even a question. What about changing the Constitution because you don't like what the court's doing? In America, I believe 4 or 5 of the 26 constitutional amendments and of the 16 that passed since the adoption of the Constitution were specifically designed to change the result of specific Supreme Court decisions. And then the Supreme Court says, okay, new constitutional provision, new decision. We're working for you guys, not the other way around. Our job is to interpret the law. In America, this Rokef Bagatz? Okay. Yes? Okef Bagatz. I got it. Okef Bagatz. So it's considered a good thing in America because that's how it's supposed to work. The court tries to figure out what the law means. Government says we don't like what you figured out. But instead of just disobeying your ruling, we're going to actually change the rules. And then that would result in that shows respect for the law, not disrespect. Maybe we're not going to listen. That's not saying we're not going to listen. We're going to listen. And since that's how you have defined the rules, we'll change the rules. So it should be simple. You don't like a decision of the court, especially in a particular case involving a particular situation, change the rules. But this Okef Bagatz thing is a serious concern. And in particular, people, what the Supreme Court would do, nobody knows. Yes?
We have a lot of questions.
Okay.
My English is not so good. I wanted to ask about Amanat Geneva the fourth.
Mm-hmm.
From who did we occupy?
Mm.
This,
Right. No, so that's about the status of the territory. So that's a whole big separate question.
That's the question.
Yes, so it's a very long discussion. I disagree that the Geneva Convention applies. Let me just give you a quick illustration. Okay. So the one view is that to occupy territory, it has to belong to another country. So in that view, no occupation, because it didn't belong to Jordan. Okay, but most of the international legal community, they want to say differently. In our case, at least. They want to say, maybe, okay, it didn't belong to Jordan. Pretty much everyone agrees to that. And it didn't belong to the Palestinians. Everyone agrees to that. But it was Jordan's enough. It was kind of, sort of controlled, de facto controlled by Jordan, such that when Israel had a war with Jordan, it triggered the application of the Geneva Conventions to the territory at the time controlled by Jordan. That's the hold on.
special for us, or is another place?
There's probably not another. But let's say that's true. Let's just say that's true. Also still there's no occupation. Why? Because we signed a peace treaty with Jordan in 1994. And the Geneva Convention is a convention about war. It also covers subsequent occupation. When does it end? When you have a peace treaty. And in no situation has the Geneva Convention been applied after a full and genuine peace has been established. So if it was Jordan's, there's no occupation, because now we have peace with Jordan. And if it wasn't Jordan's, also no occupation. Let me give you there's actually an interesting example that has just very recently happened, involving very similar facts. So Nagorno-Karabakh, yeah, you haven't heard. It's an area in Azerbaijan. But it's an area in Azerbaijan that had always a very substantial Armenian population. When Armenia and Azerbaijan became independent, the Armenians in Nagorno-Karabakh said, we want to be part of Armenia, and there was a war, and Armenia basically conquered these areas of Azerbaijan, which had a very substantial Armenian population, which were historically connected to Armenia. Okay. But under international law, this is regarded as occupied territory. Occupied by Armenia. 19 years later, this summer, the war starts again. And as ever, it's always been going to start again. Azerbaijan is going to try to take it back. They're in a better position to do so. And they actually have some success, Azerbaijan, this time. And they take some of this territory. Very small amount. Big compared to what we have here on the map, but a small strip of territory. Did anybody ever say that they're now occupying Armenian territory? Of course not. They just got the territory back. Could anyone suggest that if in 15 years, through some kind of miracle, Ukraine takes back Crimea, it will not be allowed to have Ukrainians living there because it's occupied territory? That would be a strange result. So it seems hard to understand. But the problem is in all of these cases, our case is different in one way. If you ask any Armenian government official, either in the government or in the opposition in the parliament, is Nagorno-Karabakh occupied? Of course not. If you ask any Turkish politician, Northern Cyprus, of course it's not occupied. We, on the other hand, do not have that position. And that is a real difference. That's a real difference. Yes, ma'am.
Everything you've said is interesting, but very theoretical.
Mm.
Okay? Tachlis, as they say. If you want to deal with the problem, you didn't mention anything about the Arabs. I mean, they're a factor here. I don't believe it, but they are a factor. They claim land. Okay? They must have some claim going that the courts agree with them. I don't know the legal aspects, but Tachlis, how are we solving the problem? The other examples that you gave don't have a population inside that's so violently against...
Oh, they do. We just don't hear about them because nobody cares. The Sahrawi are very unhappy to be occupied by the Moroccans. They've had a 40-year war about it.
Michael, why is Israel different? Why does the world treat us differently?
So first of all, we treat ourselves differently.
Okay,
That's an important. That's a big, and that's a. Let's say that you like human rights. You want to do something for some humans somewhere. Which humans are you going to do something for? And you're a professor. Are you going to go to the King Mohammed University in Rabat and tell them about the occupation? Maybe you'll do it, but you'll only do it once, and you might not come back. Or you're going to go to an Israeli university and get a medal. That's a big difference. Let me give you an example. Ban Ki-moon, the Secretary General of the United Nations, last year when he was the Secretary General, he went to Morocco. Talk about general things. When the United Nations talks to Morocco, they don't talk about Western Sahara so much. They certainly don't talk about Seto. It's not part of the discussion. But sort of by accident, as he was talking about Morocco, he referred to Western Sahara as occupied territories. The next day, Morocco kicks out all the UN workers, all the civilian UN workers. Situation becomes very scary for the UN people. And within 48 hours, the Secretary General apologizes for his insensitive choice of words. So you don't have to say that the anti-Semites.
We know it.
What?
We don't deal with the Moroccans. We know it.
And they're not so scary, actually. They're just serious. So the disbelief in our own cause creates a tempting target, and also the internal legal system, where it's very hard for the government to make a decision. The role of the courts, the role of legal advisors. There's lots of factors.
So what you're saying, the situation now, there's no solution.
To which part of the situation?
In general.
The Nativ Haavot situation, the government can decide any time it wants.
What?
The government can decide whatever it wants. They're afraid to decide.
So then the situation won't change.
Not because international.
No, not because of it. I mean, they're being scared a little bit with this ICC business. I think that's.
Said Bibi is afraid
He,
for international.
I think he is a little bit afraid. I don't know how afraid, but certainly the legal advisors tried to direct. I mean, you can see in the Knesset. I spoke in the Knesset in the Vadhukat about this, and the legal advisors, the advisor to the committee. This was his argument. I believe Mandelblit said the same thing. ICC. It's like a magic word too.
What's the question for international?
Well, because the ICC says this is occupied territory. International Criminal Court in The Hague. They've put maybe 5 people in jail in their 15 years of existence, but none. No, Africans.
But you say that by international law, all they can do is say we're going to pay the money. Why would the court?
No. That's by. But what I tell you is as I tell you, as you see, they may have a very different understanding of international law. Again, I think it would be very hard to put someone in jail for not knocking down houses.
In Hague, they have a different understanding of law.
At the United Nations.
You said it sounds like we are self-convinced in our particular way of making law. Bagatz invented. It's got nothing to do with international law.
Well, there are two separate problems. One is the whole Bagatz property business, and the other is the international legal issues. And they both come together here.
But this is a very important question I wanted to ask you also about it. If there are so many arguments internationally that whatever the international court is trying to prove is totally wrong.
But that doesn't mean they won't do it. That doesn't mean they won't do it.
Then it has a basis. We are talking about international law professors, experts in Europe, in the States, and we are afraid that they will that they will convict somebody against all international law. I don't understand.
Well, no, they think international law goes the other way for the case of Israel.
What you're saying
So it is double
there's
standards,
law.
that's what you're saying.
No, there is a clear law.
But anyone can do whatever he wants.
No, no.
I
If
don't
it's
believe
going-
it. Yeah.
You made it very clear that
What do you mean anyone? Who's anyone?
I think you made it very clear that international law in no case would
Except this case.
no, this isn't international, this is Bagat. This wasn't
Oh no, but also so the United Nations treats this case very differently. I said in no other case. What makes this case different? That's
pressure of
that's a deep question. But you know, from the Bagat's perspective, there needs to be some. There's going to be some point at which the government needs to decide whether it's the government or the Bagatz is the government, and this is as good a place as any, because normally, what's a typical constitutional issue in America? When is it considered the government is threatening rights? When the government is doing something bad to people, let's say, and the court says stop, and the government doesn't stop. This is an entirely different situation. Government's not doing anything, and the court says, government, you need to do something to prevent this group of private people from doing something to another potential theoretical group of private people. In America, that would not be a constitutional issue. Because first of all, there's no disputes between private people are not constitutional issues. Constitutional issue is when the government's doing something. But here, doing nothing is also considered doing something. And it's a real problem. With the Bagatz issue, I'm not the expert. Talk to Harel and none. I think Bagatz will strike it down.
But not because international...
How they do it, it's not clear. But they could say it's, they have one magic word. They could say it's disproportionate. What else do you need to say? It's easy. I think they won't have to go to international law is a bigger issue. I think they will strike it down because the Attorney General already said it. I think Bibi will be very happy with that. I think that's the best case situation for Bibi, is that Bagatz. So then he could say, I passed it, but I don't have to do it. This would be very good. But I don't know. It's hard to know exactly what Bagatz will do. By the way, this is also a uniquely Israeli thing. In America, if the Attorney General says, I don't want to defend this law, what happens is he's now the ex-Attorney General.
Yeah.
And the number two is the Attorney General. As a matter of fact, it once happened with Richard Nixon. He went through 3 in a day. And finally, the last one went and defended the law. Because in America, the notion is, and in Britain and in all other countries, the lawyer represents his client, the government. Here, the idea is the lawyer is like kind of not really fully working for the government, he's working for the law. And that's also a very unique situation. But these are the fundamental problems, and they manifest in many other ways. But again, ultimately, if, God forbid, anything is ever destroyed, it's not by Bagatz. It's by the government. And someone in the government has to give the order to do it. And they don't actually, they think they have to. But they don't actually have to. There's no law of nature. And at some point, I think the government should be ready to stand up and assert its normal democratic prerogatives. I mean, the fundamental issue is what the definition of democracy is. Bagatz said democracy, in the dictionary, means that people vote for a government and then the government votes and makes laws. That's what democracy means, based on the majority of the vote. Bagatz says that's not what democracy is. Democracy is that, except when the decisions are not good ones. Which is a different definition of democracy. But I think pressure on the government is not a useless thing. First of all, what? The government, of course. There's no law. The government's position on this is very important, because I think Bagats can also smell if the government really wants to do something or not. So if the government is like, that's the kind of cases Bagats likes, because they know whatever they say the government's going to listen to. But I think people are working on pressuring the government, I hope. Oh, that's for sure. That's very important. That concept, the concept has to be introduced. Otherwise it's only going to get worse and worse and worse. But again, Kef Bagats, it's in Israel it's like a bad word, yes? It means something like not good. That entire concept needs to be thrown out. Why? Why did Bagats make its decision? Because it read the law and it interpreted it the way it thought was right. Okay? So, but who makes the law? The Knesset makes the law. That's one thing. That is one thing it actually does say in the Israeli constitution. The Knesset makes the law. So, this is the very notion in America. There is in all of American law there is not such a phrase for like a special kind of law. It's called the new law. They interpreted one law, they make a new law. So. And this is as good an opportunity to advance that principle as any. Okay, last question. Yeah.
Are you involved in the Nativ Haavot case?
No, I'm not involved in any cases. I don't practice law in Israel. I was involved. Some of my friends were involved, but I was involved in the legislative process with Hok Hasdara. I testified in the Constitutional Law Committee a few times and wrote some memorandum there.
I followed Amona through all of the negotiations and offers that were coming, which were absolutely ridiculous, most of them.
Yes, again, Amona is not even a problem of Bagats. Amona is a different kind of problem. So this is we work very much on this at Forum Kohelet.
Are there any offers or negotiations going?
I don't know the details. But Amona, the reason they had to pass Hok Hasdara is because there were about 25 different good ideas for little regulatory administrative fixes to the situation in Amona. But the Attorney General said no. So I have to pass a law. Now, in America it doesn't work that way, and in Britain it doesn't work that way, and in Canada it doesn't work that way. And how does it work in Britain? The Prime Minister says, here's what I want to do. Find out how to do it. And the Attorney General says, okay. So nobody wanted Hok Hasdara. No, the right didn't want Hok Hasdara. Was like the last of a series of people wanted to solve the problem in Amona. And Mandelblit did not permit it, and so they had to pass a new law. Okay, thank you very much. Good luck.